Last night, on a dead-end street, a police cruiser killed its lights. No call, no camera, as far as he knew. A man in a peaked cap dropped a small bag into a stranger's yard. Tomorrow, somebody gets arrested for that bag. By noon, the footage is on your desk. You are the prosecutor. Cops build your cases. Cops are your witnesses. Today, a cop is your defendant. Everyone keeps repeating one word: immunity. Hold that word. We're coming back for it. How do you catch planted evidence? Not with a microscope, with paperwork. Every piece of evidence lives on a leash called the chain of custody. The tech who bags it signs. The custodian who shelves it signs. Every handoff gets a line. Name, badge, date, time, locked room, barcode scanner, boring forms. Boring is the point. And it is never one person. Collector, packer, keeper are split on purpose, so no single hand can rewrite the story. Officer Vance was beaten by something newer. His own body camera keeps a silent buffer 30 seconds before he even hits record. Internal Affairs pulled it. It shows him planting the bag he later discovered. The evidence is airtight. The problem is down the hall. Your office works with his precinct every day. His partners are your witnesses. Half your open cases stand on his squad's reports. Charge him, and those hallways go quiet. No law forces you out. Stepping aside is a judgment call with 3 exits: the state attorney general, a special prosecutor, or the feds. Because faking evidence with a badge on is also a federal crime. Your mentor, the senior prosecutor, makes it simple. You keep it. Your client was never the police department. You represent the people.
Pass it on or own it. And if you own it, you don't get to blink.
Now the charges. Can a cop go to jail for planting evidence? Yes, but not under one tidy law. Planting evidence is a stack. Tampering with evidence, false report, perjury if he swore to it. In California, planting by an officer is its own felony. A civilian gets a misdemeanor for the same move. The badge upgrades it to prison years. Federally, it has a colder name: deprivation of rights under color of law. And the state and the federal government can each prosecute the same act. 2 sovereigns, no double jeopardy. To indict, you go behind closed doors, the grand jury. No defendant, no verdict. One question, probable cause. Guilt is a different jury's job. They say yes.
At trial, Judge Mercer runs the room, and Officer Vance sits where every defendant sits, presumed innocent. The burden is yours, beyond a reasonable doubt. The badge does not change the chair. And here, the word suppression splits in 2. In the case he poisoned, the framed man's lawyer filed a motion to suppress, to throw the bag out. Meaning 1, the defense excludes evidence. In your case, suppression is the thing you must never do, hiding helpful evidence from the defense. That is called the Brady rule. So you hand his lawyer everything that helps him. Yes, even him. Then he takes the stand. You press play on the body cam footage. 30 silent seconds. The jury watches him plant it. Outside, on the courthouse steps, his lawyer gives the cameras the line. Time to collect that word. Does qualified immunity protect a police officer from criminal charges? Everyone assumes yes. Qualified immunity is real.
I found that evidence at the
Judges
scene.
invented it in 1967. It is not in the Constitution, not in any statute. And it blocks exactly one thing: civil lawsuits, people suing an officer for money. In a criminal courtroom, qualified immunity does not exist. An officer can win immunity in the civil suit and still go to prison for the same act.
Officer Vance has served this city for 12 years. He has qualified immunity.
2 tracks. One does not erase the other. Last year, a California officer went down in federal court for fabricating records. 7 years. Immunity never came up. There was nowhere for it to come up. In this courtroom, he is just a defendant.
You do not decide guilt. You only prove it. 12 citizens decide. But the verdict is not the bomb. The label is. He is now a Brady cop, a name on the Brady list. Proof that he faked evidence is impeachment material. Your office must disclose it in every case where his word mattered. Every arrest, every report, every sworn word radioactive. When Baltimore caught one officer planting drugs on his own camera, 34 cases were dropped and over 100 went under review. One bag, a career of convictions back on the table.
On all counts, guilty.
Andre Mills, the man framed that night, walks free the same week. Nobody films him from a cruiser this time.
Case file. What happens when police plant evidence? Now you know. Evidence lives on a paper leash, the chain of custody, guarded by different hands on purpose. Planting is a stack of charges, state and federal, and both sovereigns can swing. And qualified immunity is a civil shield. In criminal court, it does not exist. Now the verdict on the system itself. Its weakness is built in. Prosecutors depend on the same police they must sometimes charge, and civil immunity can still shield misconduct from damages lawsuits. But its strength is built in too. Evidence guarded by many hands, two sovereigns with two chances, and no badge above the criminal law. Baltimore proved it, California proved it. Real officers, real prison. Next case, you defend the man everyone knows is guilty. Same system, different chair.